Good morning and welcome to the first construction question time of 2021 with Brandon Silver. Good morning, Brandon.
Morning, Julie. Happy New Year.
And Happy New Year to you too. Okay, today's question that you're going to answer for us is, when can you terminate a contract for a failure to proceed regularly and diligently?
Yeah, so I've got two series going on now. I've got obviously this construction question time, and I've just introduced a new article section where each week I'll be talking about a different case. And last week I talked about something to do with repudiation, and then this question was brought up about a failure to proceed regularly and diligently. So I thought I would answer it this week.
Brilliant.
So many contracts require the contractor to proceed with the works regularly and diligently, this being an obligation on the contractor in the contract. Now, it has been widely agreed in case law that this requires the contractor to proceed continuously, industriously, and efficiently with appropriate physical resources so as to progress the works towards completion substantially in accordance with the contractual requirements as to time, sequence, and quality of work. So that's what the case law provides and gives an insight as to what it means to proceed with the works with due diligence. Now, one of the main contracts that provides for this obligation on the contractor is the JCT standard form of contract. And as the question has alluded to, this JCT contract, it allows an employer to terminate the contract if the contractor does not proceed regularly and diligently. Now, this contract provides a two-stage process. The first stage is that an employer must serve a default notice to the contractor setting out the failure to proceed regularly and diligently. So it must particularize what they believe to be the default. The employer can then, as per the contract, only serve a second notice following this default notice, actually terminating the contractor's employment if the same behavior, i.e., the same default being the failure to proceed regularly and diligently, continues from 14 days from the date of that first default notice. Now, importantly, this second notice must be served within 21 days from the expiry of that 14-day period. So that's the stage process that needs to be in place if you're going to terminate the contract for these reasons. Now, if you fail to comply with this two-stage process, it will mean that the employer has wrongfully terminated the contract, and that will give rise to a repudiatory breach by the employer. So that must not happen. You must meet that two-stage process. Now, obviously, there is another reason that an employer can also be deemed to have wrongfully terminated the contract in this situation, and that is if the contractor is in fact proceeding with the works regularly and diligently. So you can only terminate the contract if the contractor is actually not proceeding with the works regularly and diligently. Now, having reviewed the case law on this matter, proving that a contractor has failed to proceed regularly and diligently is in fact notoriously difficult. What you will see from a few bits of guidance that I'm going to give you now is that nothing really is conclusive evidence. So, for example, delay of itself does not provide conclusive evidence of a lack of due diligence. Likewise, the failure to produce a proper program on which to plan, monitor, and manage the work is again not decisive. Furthermore, poor labour management and inadequate supervision also does not necessarily establish on its own that a contractor is not proceeding regularly and diligently. So do not rely on just one of these things happening to think, oh, that means they're not proceeding regularly and diligently. And in any event, as I've already mentioned, even if you believe they are, you have to issue two notices, and you can only terminate if that same behaviour still carries on. So, conclusion from this at the minute is that you should exercise significant caution before terminating the contract on these grounds and relying on the contractual provisions. What I'm going to say now is to be even more cautious, because another thing is that instead of relying on the contractual termination provisions, an employer can also terminate the contract if the contractor's failure to proceed with due diligence amounts to a repudiatory breach of contract, which is what links into why this question got raised and what my article was on last week. Now, a repudiatory breach of contract is a breach that goes to the root of the contract, is a serious breach. So it's even more unlikely for this to be satisfied, and even more caution should be exercised. Indeed, it's only in the most extreme circumstances where a court may find that a failure to proceed with due diligence to be a repudiatory breach thereby entitling the employer to terminate the contract. For example, this would only be in the extreme situation of a full unlawful demobilization that materially affects the progress of the works. This just shows how burdensome it would be to satisfy this. So in conclusion, be very cautious when you're terminating the contract if you're an employer, because you could easily be seen as wrongfully terminating the contract, and then you yourself have committed a repudiatory breach of contract, thereby entitling the contractor to either affirm or treat the contract as rescinded, can rescind the contract, terminate the contract, and then claim damages themselves. If you're the contractor, however, you obviously want to make sure that you are proceeding with due diligence. If anyone has any questions of this, the obligation, how to terminate repudiatory breach, please do not hesitate to contact me. And please also check out my weekly article on a new case that's interesting. Thank you for listening.
Thank you, Brandon. That was extremely interesting. And Brandon can be contacted on brandonsilver@silverllp.com. And his article is on our website now under the articles section there. So we look forward to the next article, which will be out later on today. And we will see you again soon for you to answer yet another construction question for us. Thank you very much, Brandon.
No worries. Take care.